So we need to talk about a new case recently granted Supreme Court review, and it will now be argued in front of the Supreme Court on October 15th. This case attempts to build upon a prior 9-0 unanimous ruling by the Supreme Court, and this impacts our rights to prevent the warrantless entry into our homes and essentially avoid those types of situations. And now, interestingly, the Trump administration just filed arguments in this case. So let's break down what is now happening in this critical challenge. Now, before we jump into this Second Amendment topic, I want to address something that's very interesting and I want to bring to your guys' attention. I know a lot of you have followed the channel and you see a lot of the reports and stories and Second Amendment cases and laws that I discuss here on the channel. And maybe you've thought to yourself at one point, how do I avoid making mistakes that maybe cost me my 2A rights forever, cost me a ton of money and time away from my family? And you maybe don't know actually how to protect yourself and avoid becoming another statistic. Now, here's what I can tell you. There is a method, a legal method that I've been using for 6 years that helps keep me and hundreds of gun owners out of handcuffs. It's not legal insurance. It's not carry permits. It's something completely different. This is something that can help protect you even before one of these situations happens. But here's the thing, I've never shared it before. I've never, thought that maybe this is something that people would be interested in. But now I'm gonna make it available to you guys, and it's only gonna be to a small group of gun owners who understand that staying free requires more than just good intentions. If you're someone who would like to protect yourself and your family instead of gambling with freedom and making huge mistakes, you can click the link down below to be the first to know when I reveal some of these, secrets and information and make it available for you guys. You can sign up for free right now to get, the priority access to this information that will be coming to you guys soon. As I mentioned in the intro, in this video, we're going to be discussing a new Supreme Court case that was recently granted review, and this involves when police officers can enter someone's home without a warrant. This case tries to use a prior 9-0 unanimous ruling by the Supreme Court, which involved the warrantless search and seizure of a home and eventually the confiscation of firearms. This new challenge is very important for gun owners to understand because it involves when law enforcement can use legal workarounds to not only enter your home without a warrant, but also potentially confiscate firearms if they get into your home. This case is now set for oral arguments on October 15th, and now the Trump DOJ and the administration have filed arguments in this case, and they're supporting the state of Montana and their position. This challenge attempts to use and expand upon that prior 9-0 decision in a case called Caniglia versus Strom. Now, the facts surrounding this specific challenge is very interesting. In fact, in this case, it results out of an ex-girlfriend of an individual named Mr. Trevor Case, and that ex-girlfriend called police saying that he had threatened himself, he had threatened to harm himself, and that also maybe he had a firearm. She also told police officers that Mr. Case had mentioned to her that if police officers showed up at the home that he would also harm them, and apparently all of the police officers knew Mr. Case. He had a history of mental health issues, and they had prior interactions with this individual. When the 4 officers arrived at the home, they looked through some of the open windows, they called for him, and they did not see Mr. Case. Now, one of the police officers also noticed an empty handgun that was in a holster, and again, they tried to knock on the front door, shined their flashlights through some of the windows, but Mr. Case did not respond. Now, after spending about 40 minutes at the home, the police officers then decided to enter the home through what was an unlocked front door, I believe. So they entered through the front door, which was unlocked. Now, many of the police officers actually expressed concerns about entering the home based on some prior interactions with Mr. Case, and also based on some of the threats that were relayed to them from the phone call from the ex-girlfriend. There was also a short discussion about maybe calling his father to come to the home and maybe try to contact Mr. Case or maybe even call his cell phone, but eventually they decided to not do any of that. Instead, they entered through the front door. 2 of the police officers went upstairs, and one of them entered an upstairs bedroom. He then saw a closet curtain jerk open, and it was Mr. Case inside there, and then he saw what he claimed was a black object. He believed that it was some sort of firearm, and so then he decided to respond, and he shot Mr. Case once in the arm and once in the stomach. Now, he eventually got some medical attention after being shot, and then after searching the home, they recovered a handgun in a laundry basket that was kind of near Mr. Case. Now, in response to this, Mr. Case argued that the officers' warrantless entry into his home violated the 4th Amendment, so the firearm that they confiscated and the other evidence that they found should be suppressed. Now, those arguments were rejected by the lower court, and eventually this made its way to the Montana Supreme Court, and after a 4-3 split decision, the Montana Supreme Court agreed with the state of Montana, and they agreed that that type of evidence should not be suppressed simply because they did not have a warrant. This challenge has now made its way to the United States Supreme Court, and the Supreme Court has granted review, and they're going to hear oral arguments on this case on October 15th. The question presented for the Supreme Court to decide is whether law enforcement may enter a home without a search warrant based on less than probable cause that an emergency is occurring, or whether the emergency aid exception requires probable cause. In his petition, Mr. Case argues that while this court has recognized exceptions for the exigent circumstances, it has jealously and carefully drawn those exceptions. The court should take the same approach in defining the exigency exceptions for emergency aid and hold that officials must have probable cause to believe an emergency exists before making a warrantless home entry. He goes on to argue that the Supreme Court rejected any freestanding community caretaking exception in a case called Caniglia versus Strom. However, the Montana Supreme Court upheld the officer's warrantless entry into his home because, and they had the basis of community caretaking in the test that was already rejected. If you're not aware of what that prior Supreme Court 9-0 unanimous decision was in Caniglia, essentially what happened there is a husband and wife got into an argument, and during the argument, the husband got out a handgun, put it on the coffee table, and told his wife, "Why don't you just take it and put me out of my misery?" Now, the wife decided to leave. She stayed the night at a hotel. The next morning, she tried to call her husband, but he didn't answer. Because of that, she then decided to call police, and they arrived at the home of Mr. Caniglia, and they found him on the front porch. Nothing was wrong. However, they were still concerned about him, so they decided to take him for a psych evaluation. And during the interaction between Mr. Caniglia and some of the police officers, he told them that he did not want them to take his guns, that he did not consent to that. The police officers agreed. However, once he left for the hospital, they then approached his wife and told her that the husband had consented to them taking the guns, and so she let them into the home and they confiscated those guns. That case and that scenario eventually made its way to the Supreme Court back in 2021, and on review, the Supreme Court issued a rare 9-0 unanimous decision in favor of Mr. Caniglia. The Supreme Court struck down the community caretaking rationale, which was used to enter the home and to seize those firearms. But since then, and since that ruling, the Supreme Court has not considered the circumstances when police officers may enter a home under those type of emergency exceptions, and they have not addressed that since 2021. But now the Supreme Court is going to step back into this issue and decide if they want to expand upon what they already said in Caniglia. Now, recently in this case, the Trevor Case challenge, which is pending Supreme Court oral arguments, the Trump administration filed an amicus brief in support of the state of Montana. In that brief, they argue that the Fourth Amendment standard is reasonableness, not probable cause in all cases. They argue that probable cause attaches only to warrants, not every search or seizure. They state that since emergency aid entries occur without warrants, the only requirement is that they be reasonable under the circumstances, and they argue for looking at the totality of the circumstances. That means that in this challenge, the Trump DOJ is arguing for a lesser reasonableness standard for emergency aid situations, and they're essentially saying you don't need probable cause because you don't need a warrant, and you just need to meet some sort of reasonableness test. The Trump DOJ argues that the text and history of the Constitution also supports their position. Under the text, they argue that the warrant clause applies probable cause only when a warrant is actually sought. It doesn't extend that requirement to warrantless emergency aid actions in these types of emergency situations. Now, under the history standard, they state that the founding era practices recognized that property rights could yield when life and safety were at risk, and that meant they could do that without actually having to meet probable cause. They would only need to meet the reasonableness standard. They believe the probable cause rule is wrong for all searches and all entries, since it would delay aid and cause preventable harms and potentially tragic consequences in those types of situations where maybe people would need some help or need some aid. So they say you can't, just rely on probable cause. You should be able to help people in those situations based on a lesser standard. In summary, the government asked the Supreme Court to reject Mr. Case's proposed probable cause requirement for these type of emergency aid home entries because it is too inflexible and they need more flexibility to give aid to individuals. So now in this challenge, we've already talked about how multiple 2A organizations have jumped in support of Mr. Case and his position, arguing for a higher standard for these types of warrantless entries into the home. But here you have the Trump DOJ countering that, jumping in to support the state of Montana, and they claim that the rule that Mr. Case wants is too inflexible and they want a more flexible standard, which would be essentially a reasonableness test. This is important because it impacts everyone's protections against these types of warrant exceptions, and the Supreme Court now has an opportunity to clarify or potentially expand upon that prior 9-0 unanimous ruling in the Caniglia case. As I mentioned, oral arguments are now going to happen and they're set to take place on October 15th. So this is something that we're going to be looking forward to and watching closely. But it's interesting that the Trump DOJ has now filed an amicus brief in support of the state of Montana, and they're arguing for a reasonableness test. And it's going to be interesting to see if that sways any of the Supreme Court justices to the other side, arguing for a lesser standard. So that's what's currently going on in the critical warrantless search and seizure challenge that is currently in front of the Supreme Court. As we get more information, as this develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armedscholar.com. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.